All right, sir, you're Dalvius Williams. And Mr. Williams, in cause number 25 DCCR 0176, you're charged with a third-degree felony offense of injury to a child.
Quick pause injury to a child is a third-degree felony in Texas is no small matter where you're talking to 10 years behind bars. Notice how the judge makes sure Mr. Williams really grasps that risk before moving forward.
And you're found guilty. The range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 4-year term in the institutional division. I'm assuming that would run concurrently with the time that you're currently serving. You have every right to reject that and have a jury here and decide your case. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
I do want to make sure you understand, Mr. Williams, that after today, I will not accept this plea agreement. Once your case is on the trial docket, it'll go to trial, or you can change your mind and plea open to me or plea to something different, but it's not going to be this plea agreement. Do you understand?
Yes, ma'am.
I just don't want you to think that you're going to sit in jail and things are going to get better somehow, right?
Yes, ma'am.
Okay.
Judge, I would also like to put on the record that if he's rejecting this offer that would run CC.
And here's the real kicker: if Williams is convicted, the state can stack his new sentence on top of the one he's already serving. Audience question: would you take the 4-year plea or roll the dice on a trial?
The state will file, have this, whatever he receives in this from the jury, to be stacked on top of what he's already received in the interior.
So I do want to make sure you understand, depending on the timeline of all that, there is the possibility that if you're found guilty in this case and whatever punishment you receive could be stacked or run consecutively to that sentence that you already received. Do you understand?
Yes, ma'am.
And do you still want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get that done. Mr. Williams, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and appoint someone else today that can begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Rojas, you are released. Mr. Williams, we will appoint someone today, and they will begin preparation for trial. All right, you can get back with the bailiff. That may be one that we try to find a space for to get taken care of. He just wants to hang out in our jail. I said maybe try to get that done a little quicker. Just because I think he's, anyway.
Probably in his phone. That's attorney personality.
Yeah. We only have so many of those.
I understand.
I can, but yes, I don't disagree with that.
Not that you're not, Charlie.
Could have waited till I left.
We could have left you on it.
No, I think he and I are not.
Yeah. Yeah. Let's see, Kevin Ross, Mr. Burbank.
No.
You got those in too, thank you. I- Good morning, are you Kevin Ross?
Yes, ma'am.
And Mr. Burbank, will your client waive the formal reading of the motion in each case? Mr. Ross, in cause number 24, DCCR 1198, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 18th of 2024 for the offense of deadly weapon in a penal institution, a third-degree felony, and that was a deferred probation for 4 years. Is that correct?
Yes, ma'am.
It alleges that you, I'm sorry, and then I also have cause number 24, DCCR 1199, also a motion to revoke your unadjudicated probation. This shows that you were placed on probation December 18th of 2024 for evading arrest or detention with a motor vehicle, a third-degree felony, and that was also a 4-year deferred probation. Is that correct?
Yes, ma'am.
Tell me again why we're doing this.
Now we're with Kevin Ross, already on probation for 2 felonies and 6 months later. He allegedly commits the same crime again. The irony here is brutal probation is a second chance, so he might have blown it almost immediately.
They have yet to submit the case formally to be indicted on the evading, so our thought was to allow that to come in, maybe hold it, see how he participates in ISF. Certainly, if based on those circumstances we need to rediscuss it, we can. I don't believe he's had any write-ups while he's been in. I mean, obviously the new offense was quite egregious.
Well, and that's my, if you're on probation for that and then you do it again, six months after you were placed on probation?
No, I would only ask to let him go. That charge is still out there. And then we can address it depending on what the court wants to do when we come in front of the court again.
But if he pleads on it now, then I don't think even if it's indicted, I mean, if he pleads true today
Right.
to the new offense, and I do what I do on these motions and reinstate and send them to ISF, if the case is then submitted, or when it's submitted, you can't allege the same thing again and then me re-punish him for the same offense that he's already.
It's the new offense that you would address.
But y'all said that today. Count one is the new offense.
Right, but
I
it's-
can't do it twice.
Well, if once it comes back, once it gets indicted, then it can be addressed.
On its own absent.
Yeah, on that, not the NTRP, but the new offense.
Well, I know, but then we have two probations and a new offense, and the argument then is gonna be, we'll leave him on probation because you can't revoke him because you already did this. Because I already took it into
But you also
consideration
have
on
the
these
option
motions.
of leaving him on probation and then sending him to the penitentiary if he doesn't do well on the new offense. See what I'm saying?
I know, but that's just, I mean,
Would you
any
prefer,
word
Judge,
on
I
where
just-
that is,
that I
why
just
they're,
reach out to them again? I know last time it was kind of in the context of that conversation. If you
yeah,
don't want me to call them, you're gonna call them.
yeah.
I can do that, and I can get it to grand jury by next Wednesday.
I just would like more information, I think, before, on that case. I don't think we need to have them on a probation, and then those out there pending, and then in the middle of ISF, they send it. If a warrant's issued, they're gonna kick them out of ISF anyway.
They were gonna hold it until he got out, Judge.
I'm gonna reset it just a short time. If you will reach out, or if I need to reach out, I understand, I appreciate that they, I guess, cooperated somewhat with getting the video, but I think I'm gonna look into that a little more myself and find out where it is in the process and why it has not been
Yes, ma'am,
submitted.
Because the offense date is June 13th.
Yeah, that it makes no sense to me. And from what I recall, it was not just a couple of blocks going slow. It was, okay,
I'll have investigator Bates reach out this morning, and we'll get it indicted by next week. If maybe an update would be beneficial.
that's what I'm thinking. I think I'm not gonna just automatically do it. I think if there's gonna be pleas, we can do an updated PSI. I wanna know more about everything that's been going on before I agree to something like this. All right, you can go back with the bailiff. Would you put a sticky on that for me to contact? DPS. Just do 3 weeks. This knows it's. And I'm deleting the paperwork just because their dates will be wrong. So even if that's what y'all do next time, we're gonna have to do it again. Mr. Lewis, on Gerson Mendoza, Ms. Burge? I've got it over here.
Enter Jerson Mendoza, just 18. The judge takes his age seriously, but don't be fooled. Aggravated robbery is a first-degree felony punishable by up to life instead of prison. Gets probation with conditions like ISF and a GED basic life probation plus life skills boot camp.
0304. And are you Gerson Santa Maria Mendoza?
Yes, ma'am.
Mr. Mendoza was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. The agreement was for a 10-year deferred probation and a $1,000 fine. I've received the pre-sentence report. And has everyone had an opportunity to review that report?
Yes, Judge.
Are there any additions or corrections?
Not for this day.
So, Mr. Mendoza, you're only 18, is that right?
Yes, ma'am.
All right, so if I'm going to follow this agreement based on your age, the nature of the offense, the fact that you withdrew from school and haven't completed high school, I'm going to up front send you to the program called ISF. It's a 90-day program, and it is intended to help you to make better decisions. Because of your age, obviously, I want you to be successful on this probation, but I think there needs to be some involvement by other people to help you do better. Does that make sense?
Yes, ma'am.
So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and follow all of the rules and conditions of probation. That's including going to and successfully completing the cognitive track of the ISF program. If you do everything you're supposed to on this probation and you successfully complete it, this is a great opportunity because you don't have a conviction for a felony on your record. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court, found guilty, so you would be a convicted felon, and you could go to prison for anywhere in the range of punishment, which is a minimum 5 years up to the rest of your life in prison. Do you understand?
Yes, ma'am.
Also, a condition of your probation is going to be that you get your GED. So once you get out of ISF, you're ordered to start that process within 45 days. Okay. All right, I'm handing you the trial court certification. That shows that this was an agreement that I followed, so you waived your right to appeal. Okay, good luck to you, sir. Thank you, Ms. Burge, thank you. They might. You can let them know too, you might be able to start your GED in ISF. So check into it.
Because TDC does have a good program.
Yeah, I just don't know if ISF does, but that would be good to get
That's where
started.
he's gonna be.
Yeah. Okay. Okay, let's see. Mr. Parker, on Brian Papania,
They didn't bring him, Judge.
because he just turned himself in on,
Friday.
Yeah, they're going to get him.
oh, they're bringing him now? Okay. James Bruno, Mr. Parker?
We're ready.
James Bruno?
Oh, dude, that's just not. You're bruised?
Uh-huh. Uh-huh. Good morning. Are you James Allen Bruno? And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Bruno, in cause number 24, DCCR 1151, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from April 21st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 6-year deferred adjudicated probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Yes. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Bruno is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Ms. Malfino?
Judge, he's not from here. I have a little bit of hesitation with his Louisiana history. If he does, in fact, have any, I cannot see any in the NCIC.
Notice the judge's strategy here. Lowering bond to $1,000 sounds generous, but the GPS ankle monitor flips the deal its leniency mixed with surveillance smart. Move would you trust him to come back to court without it?
TCIC, but due to the fact that he's not local, of course, defer to the court, but I would appreciate if we could just hold him for those couple of weeks with PSI coming.
Your Honor, the only record I know he has,
It's gonna be-
he has a misdemeanor marijuana charge from way back, and no felony history at all.
So where are you going to live when you're released? Where do you live?
I live in Louisiana.
Where in
Lafayette.
Louisiana?
Lafayette.
Lafayette.
I work
So,
in Baton Rouge.
I'm
He
sorry.
works in Baton Rouge.
Okay, so here's what I'm going to do, Mr. Bruno, based on the nature of your plea. I'm going to reduce your bond in your case to $1,000. Until sentencing, if you make that bond, I am going to require that you wear a GPS monitoring device. And so you'll need to get that taken care of. They'll put it on at the jail. That's just to make sure we know where you are and to make sure you get back here for your sentencing, okay? Once you get on probation, I don't anticipate that you'll have to continue wearing it. That's just a bond condition to make sure, since I lowered that bond, that you have that incentive to come back when you're supposed to, okay? All right. Okay, thank you, sir. You can go back with the bailiff.
Well, Your Honor, also, you might tell him if he gets out about.
Oh, yeah, so
I'm sorry.
Mr. Bruno, yeah, thank you. So also, if you make that bond before probation comes to talk to you at the jail, don't go straight to Louisiana, go straight to probation. Okay, you've got to go straight there. She's going to give you some paperwork today that shows you where to go. You've got to do that interview and get that appointment made for that pre-sentence report. If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be worse.
No, I understand.
And then also, if you're arrested for anything, obviously between the time you bond out and if you come back for sentencing, you've been arrested, then you run the risk of me not accepting that agreement. Okay, thank you, sir. You go back with bailiff. Thank you.